Hello, so this is a occasional webcast for the Technology Commercialization Law Curricular Program and SIPLI at Syracuse University College of Law. I'm Professor Shubha Ghosh. I'm the Crandall Meldovan Professor of Law at the Syracuse University College of Law, and I'm the director of both the Technology Commercialization Curricular Program and SIPLI. And if you want to get more information about both of these, please look at the link that's available below. So what I wanted to do today is very briefly talk about this recent Supreme Court decision in Helsinn versus Teva. This was sometimes referred to as the patent case of the century. It's a lot of hyperbole associated with this case. Basically, the issue was whether the American Invents Act changed Supreme Court precedent on prior art, and the holding in a 9-page opinion is very straightforward. The AIA did not alter precedent. And so, at some level, in my opinion, the result was fairly predictable and not that surprising. But there was some controversy about what exactly the AIA did regarding secret prior art, and there was a view that AIA had overruled cases, even maybe cases like Pfaff, cases like Engelbert, cases like Nicholson, other cases in which the prior art had not been disclosed to the public, but nonetheless was held to be invalidating. It turned out the AIA did not really change anything, and so we are left with the old Supreme Court precedents as the basis for how we understand the AIA. So that's the bottom line. Some background for the case. The ruling came down on January 22nd. It was a closely watched opinion regarding secret prior art and how AIA affected precedent on prior art. And it was a unanimous ruling. AIA did not abrogate court precedent. There was no clear statement from Congress. So the facts at issue of the case are fairly straightforward. Helsinn makes a drug using chemical palonosetron to combat nausea from chemotherapy. Helsinn entered into a proprietary confidential agreement to market the drug in 2001. Company files patent applications in 2003 and 2013. And so the dates of the patent applications are relevant here. 2003 is pre-AIA. The AIA went into effect roughly in 2011, and then 2013 applications were subject to the AIA. So the issue is whether these proprietary confidential agreements to market the drug would be invalidating under the AIA. There was no question that they would be invalidating under the prior law, and so the applications in 2003 could be rejected based upon this prior art. The question is whether the application in 2013 could be rejected based upon this prior art. So, were patents obtained from 2013 application invalid because the invention was on sale more than 1 year before the date of application? And the question is what exactly that 1 year before date of application means under the AIA. And so the lower court ruling was that the patents were not invalid because under AIA, invention was not in public use on sale or otherwise available to the public before effective filing date of the claimed invention. And so the key here is this otherwise available to the public. The district court view was that this otherwise available to the public was modifying both public use and on sale, that the otherwise available to the public meant some sort of public disclosure. Helsinn had entered into confidential agreements that were protected under trade secret law, and therefore they were not otherwise available to the public, and therefore would not be on sale or a public use under the AIA. Federal Circuit reversed, however, ruling that the AIA did not change the meaning of on sale. The language of this is basically creating three distinct categories: public use, on sale, or otherwise available to the public. Three distinct things. The last one does not modify the previous two. And so that's how the Federal Circuit read the language in the AIA, and therefore the meaning of on sale was not affected by the AIA. It basically took the meaning that had existed in the 1952 Act and had been interpreted by the courts in the various precedents that we'll list in a few minutes. And so the Supreme Court granted cert on this case last year, and of course many people predicted that maybe the Supreme Court was granting cert on a Federal Circuit decision to reverse the Federal Circuit. Though, that may not be a bad rule of thumb, but keep in mind that I think looking at most recent statistics, the Supreme Court reverses the Federal Circuits around 70 to 75% of the time, which means 25 to 30% of the time the Supreme Court, affirms, and that's what happened here. Here, the Supreme Court unanimously affirms, really finding that the AIA did not change the meaning of on sale. The plain meaning of AIA would to treat public use, on sale, and this otherwise available to the public as distinct categories. And so the precedents at issue here, Pennock versus Dialogue from 1829, established the on sale bar. The various cases here, Consolidated Fruit Jar Company, Smith and Gregg versus Sprague, Elizabeth versus Pavement Company, and then Pfaff versus Wells, the most recent Supreme Court case on the on sale bar, basically all involved on sales, the particular invention that was being on sale, without there being any sort of public disclosure of what the invention was. Certainly the case in Pfaff versus Wells, a 1998 case, where the court said that for an invention to be on sale, there had to be a commercial offer, plus the invention had to be ready for patenting. No requirement that the public have a disclosure of the invention, though ready for patenting does mean that the patent application is ready to be drafted at that point in which the sale was made. So the precedent clearly did not require any sort of public disclosure, and the view was that the AIA did not change this. If you look at Federal Circuit precedent, Special Devices versus OEA, secret sale by the patent application was found to be invalidating in 2001, though it was in the context of stockpiling for the purposes of sale, but the stockpiling aspect of the case does not seem to be relevant. Next, the Woodland Trust versus Flower Tree Nursery case from 1998. Again, secret commercial use by patent application is invalidating. So the interesting question then is what's left open? Basically the Supreme Court did in Helsinn is, again, in my opinion, was not too surprising. Was to basically say on sale in the AIA means what it says, and that meaning was not changed. So one issue, of course, that arises is what exactly do we mean by this otherwise available to the public? Lots of questions about what that might mean. It might mean patenting. It might mean publication. It means some other type of public disclosure. The general view is that this was meant to be a catch-all, not to modify public use or on sale, but to capture the various ways in which an invention may be publicized or published with the information about the invention made available to the public. So there might be some interesting cases interpreting otherwise available to the public, how broad or narrow that is, but what the Helsinn case is saying is that that clause does not change the meaning of public use or on sale. One open question is, what about third-party secret sales? This is an issue that the Supreme Court has not addressed, even though the Federal Circuit has in Gore versus Garlock in a 1983 opinion, where basically the court held that a secret public user sale by a third party is not invalidating. There has to be some sort of notice to the applicant, perhaps, though I think Gore versus Garlock is stating something probably much more narrow than that, which is saying that secret public user sale by the patent applicant is invalidating, but if it's done by a third party, presumably unaffiliated with the patent applicant, then it is not invalidating. The Helsinn decision does not affect this ruling. So that ruling has not been overturned or even addressed in the Helsinn decision. Um, there may be some suggestion when you look at the language of Helsinn that it's this public access that's important, though it's not completely clear whether in Helsinn the court is focusing on just public access generally or public access from which the patent applicant benefits through some sort of sale or public use. So the Supreme Court may at some point address the issue of third-party secret sales, and perhaps Gore will be overruled. The argument would be not otherwise available to the public, suggesting that questions about how to interpret that language, if it's interpreted to mean public disclosure, then a secret public use by a third party is not a public disclosure. Therefore, it could serve as prior art that invalidates. It's an interesting question about how all this will fit together. On sale within 102 seems to refer to on sale by the applicant. And so perhaps not otherwise available to the public will have a different meaning when it deals with a sale or public use by a third party. And so this is where maybe the heart of Helsinn lies, that traditionally public use and on sale bar applied to acts by the patent applicant. We are left open as to how acts by third parties not affiliated with the applicant will affect patent validity. So the Supreme Court might address that issue, and we are left to see exactly how that would be result. But the bottom line is that Helsinn basically maintains the status quo. AIA did not change anything regarding the meaning of public use or on sale, and therefore the old precedents from both the Supreme Court and the Federal Circuit are still valid. So I'll be glad to take any questions. Feel free to email me or with your comments or questions about the case. There are several other Supreme Court cases involving intellectual property this term, and I will have an occasional webcast to discuss those cases as the Supreme Court decides them. So thank you for your attention. I hope this brief webcast was of use.